All right, we are back on the record. The record will reflect the presence of all jurors, all counsel, and the defendant are present. All right, Mr. Carlos, would you like to deliver your closing?
Yes, sir.
Whenever you're ready.
Good afternoon, ladies and gentlemen. Hope you all are a little bit more awake this afternoon, and this is the only time I'm going to get a chance to speak to you. The government gets to, the prosecution gets to go again because it's their burden of proof. So I just get this one chance, one opportunity to discuss this case with you, what it means to the defense, what is missing from the prosecution case, and how you should use the law. So it's important really to kind of put this in perspective, all right? And you really need to put this in perspective. We see cameras everywhere. You know, we see them on the outside. They're doing reporting on this. It's on the news. It's on the internet. But the only thing that matters, are you people right here, all right? You know, you've heard people say, you know, what makes America great? This is what makes America great. A jury of one's peers, 12 people selected from the community who have pledged an oath to be fair, to not attach labels to people, to apply the law, and to do the right thing. It's a difficult thing to do. Essentially, you hold this man's life in your hands, Mr. Winslow. And aside from a doctor, nobody really has that power, shall we say. Nobody has the ability to affect somebody's life like a jury does. That's why it's important when you're listening to the arguments, when you're going through the evidence, you realize your position. And your position is lifted, elevated from where we stand right now. You are looking down on the proceedings. What you have witnessed, what you have seen over the last 3 weeks, is exactly what you would expect in a criminal trial. You have seen a hardworking prosecutor and his team put their case together. He's done it honorably and with respect. You have watched a defense team do what we have to do in order to defend an individual. I mean, do I enjoy cross-examining people who are accusing my client of sexual crimes? Do you think I enjoy, you know, sometimes being very, very aggressive to get to the truth? No, but that's my job. You wouldn't want it any other way. If you had a family member, if you had a friend who was accused of a crime, you would want exactly what we have done for Mr. Winslow. Because what we do is try to get to the truth. Prosecution presents their case, that's the truth that they believe to be. The defense gets to the truth through cross-examination. And that's what happened here over the past 3 weeks. So you saw both sides, prosecution, defense. You saw a judge who has ruled throughout this case, trying to keep things fair. And that's what he did from the bench. But now, we turn it over to you. And there's nobody, and I mean nobody, that can impact your decision but yourselves. And the only way to do this justly and fairly is to apply the law. And it starts with the presumption of innocence. You know, Mr. Winslow is presumed innocent until proven guilty, all right? When you guys walked in here from voir dire, when we asked you questions, we sat here at this table. He was innocent until proven guilty. The first witness takes that stand, the second witness takes that stand, the third witness, to where we are right now. He is innocent until proven guilty. It's until you get back in the jury room and you discuss the case and you discuss the facts amongst all of you that you can make that determination. So when you're viewing the evidence that's been presented by the people, you need to view that evidence as if Mr. Winslow is innocent, right? Not guilty, innocent. You have to make them prove it. This is not about him. This is not about who he is or what he represents. He is just like any other criminal defendant in this country, and he's just like any other citizen in this country. Anybody who's watching it on TV, anybody who's outside, anybody who's walking around. If they were accused of a crime, it would be the same standard of evidence, the same burden of proof. And we would hope that a jury would stand up and do the right thing and apply the law. That's how important it is. Now, understand what the prosecution is attempting to do in this case. While Mr. Owens was up here, I counted 21 times that he said there were 5 accusers. 21 times he said 5 accusers, 5 accusers, 5 accusers, 5 accusers, 5 accusers. Another 9 times he said this is a deviant. He's a sexual deviant. Think about what's happening here. You know, he also, I should mention also that he accepts that there are some major league holds in every single case that he has presented to you. He told you that. That's why he's telling you to put them all together. Because there's 5 accusers, 5 accusers, 5 accusers, 5 accusers, 5 accusers, sexual deviant. He wants you to forget about the holds. He wants you to forget about the lack of evidence, and he just wants you to take bits and pieces from each individual victim and make the other cases stronger. And that's not the way it goes. You will not get in the instruction packet is going to go back to you. You will not get anywhere an instruction that says where there's smoke, there's fire. You will not get that one. But what you will get is that each charge has to be proven beyond a reasonable doubt. Each and every charge. 3515. Each of the counts charged in this case is a separate crime. You must consider each count separately and return a separate verdict for each one. Do not fall into the trap of picking pieces of evidence and making another case stronger. It doesn't work that way. You have to be convinced beyond a reasonable doubt first that he's guilty of that crime. Jane Doe 1. Let's think about Jane Doe 1, right? First victim up. I want you to take this, when you think about Jane Doe 1 and all the witnesses in this case, I'm going to tell you how you have to view this evidence. Because we live in a country where somebody can point a finger at somebody and that is enough. Right? That's the good thing about our law. Yes, Mr. Owens is 100% right. Sometimes there's only one person. I got robbed. You robbed me. But still, there is evidence that's presented to support that particular finger point. And that's called circumstantial evidence. So when circumstantial evidence is presented to you, the law tells you how you should view that evidence and how you should apply it to the case. Cal-Crim 224, the circumstantial evidence, sufficiency of evidence, tells you this, right? If you've got a piece of circumstantial evidence that's presented, and it's subject to 2 reasonable interpretations, right? One that points toward innocence, and one that points toward guilt. The law requires you to adopt the one that points toward innocence. It's in the instruction. You must accept the one that points toward innocence. This is not a suggestion. This is not, guidance where you say you might, you can if you think about it. Maybe you can. Well, if you feel like it, you can. No, you must adopt the one that points toward innocence. So each and every piece of circumstantial evidence, you have to apply the jury instruction, and you have to apply the law. Which means that if it's reasonable, you can't say, well, that's reasonable, but he's probably guilty because of this. No, you're misusing the law. You also have to look at the witnesses. Cal-Crim 226 tells you how you should look at the credibility of the witnesses, and that's what this case is. Credibility of witnesses. How well the witness could hear or otherwise perceive the things that they testified to. What was the witness's behavior while they were testifying? Were they combative? Were they honest? Were they influenced by something of like bias or prejudice? Maybe a motive, maybe a financial motive. Was the witness untruthful? Was the witness untruthful? So the law tells you that you should consider, particularly, somebody who is untruthful. And in this case, you have somebody who's not only untruthful, especially with Jane Doe 1, but is an admitted liar. All right. I want you to do this for a second. And I want you to imagine You're looking at Exhibit 114, which is a view of the parking lot and the freeway on-ramp, all right? And I want you to imagine for a second, this is a movie, scenario, right? And it's a movie with no sound. And you come down, and now you can watch what's going on. And there's a woman up the road here, and she's sitting on the side of the road in white leather pants with her thumb out. Again, you can't hear the sound. Black vehicle pulls up. The woman goes to the passenger side. There's some pleasantries exchanged. You still can't hear what's going on. She gets into the vehicle drives down the road, pulls into a parking lot, passes many parked cars. Bank, grocery store, cleaners, fitness, goes all the way back to the back parking lot, right? Still, no sound. You see the man get out of the driver's side, walk around to the passenger side, and open the door for the woman. Again, no sound. You then see the man, you see these open doors. The man walks toward this field. The woman follows him. Right? Still no sound. The man climbs over the fence, starts to take his clothes off. The woman is on the other side of the fence, looking at him. She takes her backpack off, she throws it up over the fence, climbs over the fence, and now she's on the other side of the fence with the man. Still no sound. You can see them talking to each other. The man jumps back over the fence, back toward the parking lot. The woman takes her backpack, throws it back over the fence, climbs the fence, and now she's in the parking lot again. She follows the man behind him back to the car. The man opens up the passenger side, shuts the door. Then you see something happening inside the car. The woman's head goes down, and then a few minutes later, she is ejected from the car. The side door opens, passenger door is open, she's out on the street, this car starts driving away, and this person is chasing the car, screaming. Oh, I didn't mention, you're still watching this. As the car drives away, down and out in the parking lot, this woman, she just starts walking past all kinds of people and continues her day like nothing happened. So, like I told you, it's a movie with no sound. What does that look like? And what's it look like to you? You know, is a reasonable interpretation that there's some type of transaction that happened or some type of encounter, like a mutual encounter? Does it look like somebody got picked up and threatened and beat and raped? No, it doesn't. It's a reasonable interpretation of the facts, ladies and gentlemen. That is a completely reasonable. It's not even going anywhere near any type of imagination. So when you look at her story, she's hitchhiking. Now, think about this, too. This is a woman who told you that she has only hitchhiked 5 times in her life. And the last time she remembers, she was 12 years old. So now, at the age of 55, when she's 1 block from her house, she decides she's going to hitchhike. And there's absolutely no reason for this at all. And, I mean, just to throw into the mix, her daughter says she's extremely paranoid. So what is an extremely paranoid person doing hitchhiking? Since the last time she could remember, she was 12 years old and something bad happened to her. She told you she was wearing the white leather pants on her way to the coast, highway, and downtown city is to quote-unquote cruise around, which is what she does. She got tired of walking after 1 block. She likes to walk, she says, but 1 block, and she decides to put her thumb out. In the parking lot, we heard testimony, we saw the photos. It's a crowded lot because it has these stores in it. It's got a Vons, it's got a bank, it's got 24-hour fitness, cleaners, sushi restaurant. All of that is there with a major parking lot by the freeway. This is not some excluded or some type of secluded location. This is in broad daylight in public. The photo that was Exhibit 23 that was shown to you in court really fairly inaccurately depicts it. You see the cars that are parked there. This is not an empty parking lot in the back. Cars parked there, people walk there. The doors to the sushi restaurant and the cleaners are visible in the photo. At no time did she ever even attempt to yell, to scream, to run, or even to walk away from the situation. The fence is important, really important here, because if you look at the fence and you see the prosecution during their examination, they tried to say, well, the ice plant is up, climbed up, and so it's not that big of a distance. But you heard her own testimony, and if we accept what she's saying is true, she used the brown marker there on the wall as the height. All right, that would be the second band of the brown marker there. With this top of the fence, which is, there's not a bar there. It's actually just exposed wire. And I suggest to you, ladies and gentlemen, it takes a lot to climb over that. I mean, it's not like something you hop over. It's something that you have to physically put your hands on, maneuver your body to get up and over this fence. So it takes effort. It takes the desire to get over the fence. Another telling thing is, she made sure to throw her valuables over the fence. She didn't want to leave them on one side of the fence. She put them over the other side of the fence and then followed them with her. And then once she was on the other side and they decided to go back, she threw them back the other way. Now, what's important is, of course, she's told you, she testified, that the man who was going to rape her, the terrorist, was on the other side of the fence with his clothes off, and she was on the safety side of the fence within, you heard my investigator, 17 seconds, 22 seconds, 24 seconds, 26 seconds to safety. And that's, I don't want to disparage my investigator, but that's an older man walking. I mean, he's just walking. It could take, if you're moving, it's even quicker. If you turn around and yell, it's easier than that. If you take the phone out of your backpack and dial 911, regardless, there's a naked man on the other side of a fence. I'm sorry. They're gonna have to say, we take our victims as we find them. Well, she's not. She's not a victim because clearly she's not frozen. She climbed a fence. She put her hands into a chain link fence and climbed over a fence. Took the care to throw her valuables over the fence and did it again. It's not a victim. The walk back to the car. She followed him back to the car. This man didn't pull her by the arm. The man didn't grab her by the scruff of the neck. She followed him. He even opened the door for her and she got in. She was within feet between the distance of, I think she said in court, it was like from me to you, an open door. That's how far she was from an open door. You mean to tell me, really, seriously, that a woman who's climbed over a fence twice now, has driven by, multiple people in a parking lot, by multiple cars, is so frozen that she can't turn and walk 15 feet to a door? And don't tell me that, they would think that I'm kind of crazy and they wouldn't pay attention to me. You know what? Being crazy and attracting attention is one way to stay safe if you're being raped or about to be raped. Because you know what's going to happen? The police are going to show up. She didn't do any of that. Why? Let's think about that. Apply the circumstantial evidence, because all of this is circumstantial evidence. Why? Because she wasn't being raped, nor was she in fear for her life. Back to our movie. Inside the car, Jane Doe 1 told you that she leaned over to give him oral sex. She told you that he didn't grab her head. She told you that she didn't force anything. And she told Benavides that the Officer Benavides, that the oral sex wasn't forced. The way she described it, think about it. She actually did it. She pulled up 2 minutes later, she said, on her own. I mean, she described the size of his penis, we all heard that. I mean, she was there. But clearly, it was an act that she was engaged in. She stopped doing it. You heard her testimony. She stopped giving the oral sex on her own accord and started to undo her pants and take them off. Now, the man inside did not force her to do this. She did it on her own. Once again, all of this is consistent. Every single piece of evidence here now is consistent with a consensual encounter. She then told you, said, bring it on. Get this done. Not help. If she can scream, bring it on, she can't scream help. She can't do anything. She sounds like a tough woman, right? You saw her testify. You're telling me for a second that she is frozen in fear. The man climbs over, according to her, the man climbs over the seat to have intercourse with her. And I suggest that that might be a little difficult. Maybe it occurred somewhere else, if it did. But you saw the pictures of the Hummer. You know, Mr. Winslow, 6'4", about 245 pounds, with a woman there inside that front seat of the Hummer. Now, you heard Mr. Owen say that whether or not she was menstruating isn't such a big deal. It is a big deal. The reason it's a big deal is because what you have is a victim who is making things sound worse than they were. In other words, you make it look like this was a violent attack. If you were bleeding because you were viciously sexually attacked, that's different from you were menstruating. So the questioning about her menstruating is important for that reason, because it shows that she is willing to play hard and loose with the facts, so to speak. She will lie if she has to, but certainly it's not the result of her being assaulted. This is trial testimony. My question was, did you feel yourself bleeding? The answer was yes. And I have to ask you, but at this point, were you menstruating? No, I wasn't. Okay? This was this witness from this stand to you all said, no, I wasn't menstruating. In the same examination, just so we're clear, you're saying now that you weren't menstruating that day, right? She said, right. Okay, so the blood that you had that day was a result of some sort of trauma. She says, yes. She's telling you guys that. Okay. And I say, some tearing, literally? She says, right. And I say, you know your body. She says, yeah, it feels like my water bag broke or something, and it was like gushing. It was all red. It was just a lot. It felt like a lot of water, but it just gushed, like all of a sudden just swish, something like that. What's she doing? Right? She's claiming this blood is a result of her injury. But the reason we have cross-examination, it's the ultimate truth-finding tool for people like myself who do this for a living. You find out a lot of things when you start asking the right questions. Once you start prodding people, when they're not questioned, you can say anything they want, but once they are under cross-examination, things change. During the same examination, I said, you were asked about menstruating. She says, yes. Do you recall what you said? You said, I guess I said I was on my period. We're referring to a previous testimony, previous preliminary hearing when she said she may have been menstruating. So back then under oath, let me ask you this. Do you recall saying, the question to her was, but now the truth is you were menstruating. She said, this was her answer. I guess, yes. I guess I was menstruating. No, I wasn't. I guess, yes. Okay, yes, I was. All right. Well, this is a completely unreliable witness saying anything she needs to say at any given time just to get on to the next question. And I say, do you remember saying that? She says, well, if I said it, I said it. I say, okay, do you remember saying that? Yes, which means that you really don't know whether you were or you're not menstruating. She says, yes, I was menstruating. I said, so the blood that we're talking about here from menstruating, here is from menstruating rather than being penetrated and assaulted. Is that correct? Yes, I guess so. So what you witness is essentially why cross-examination is so valuable. Because in front of you, right, in front of you, you can go back through the testimony and you can watch it all transpire. You know, a witness lied to you, the lie was exposed, and she admitted to it. And you have to question whether or not you can accept the credibility of this particular witness, of this particular accuser, when assessing the evidence against Mr. Winslow. So the evidence of the blood is still important because menstruation or not, there is no blood inside of the Hummer. Zero. If it was gushing, if it was spotting, if it was all over the place, like Jane Doe once said, there would be nothing, there's nothing there. You went over with a fine-tooth comb, and you can feel the prosecution start to panic when they say, oh, they had it cleaned, you know, it was detailed. You know, they showed you the nice fancy picture of them detailed. You know what they didn't show you? They didn't show you the fact that they didn't bother to even interview the detailer. This guy left. They see him do detail. They could have said, hey, let's stop him and find out what he's asked to do. Did Mr. Winslow come out to you and say, hey, you know what? You need to clean this seat here. There's a bunch of blood all over it. Or you need to use some extra cleaner over here because there's a bunch of blood on it. There's a bunch of DNA. You know, that might have been something helpful. They could have said, Mr. Winslow told me to go extra hard on some of these parts. But they didn't bother. They didn't bother to ask the question to the cleaners. And then they have the audacity to come in here and tell you that that is consciousness of his guilt. They're asking you to speculate. The same thing with the sale of the Hummer. They know who he sold it to. Did you see any interview with them? No, because they didn't. They want you to speculate. They are throwing things up for you to attach a guilty persona to Mr. Winslow. The mere fact that they can actually tell you to take those into consideration for consciousness of guilt, you should turn it right back and throw it back in their face because they did absolutely no investigation, none, zero, other than to observe it and then attach a meaning. So, you know, the sale of the Hummer, the cleaning of the Hummer mean nothing. These are 4 months after the event. He could have cleaned it at any given time if he was worried about having any type of evidence inside his Hummer. The last part of this, Jane Doe 1, the ejection from the car. You know, it's interesting what she said. Remember, cross-examination is a truth-finding tool. You know what she said about getting out of the car? She said, he just got mad. He just goes, just get the fuck out of my car. And he's just, you know, he was just mean. All right, I want you to think about that for a second. Somebody who's been raped, picked up, kidnapped, taken to a remote location, I guess brutally raped, what they're saying. She's saying the guy was mean? Really? When we go back to the circumstantial evidence, is that not the statement of somebody who's engaged in some type of, I guess, mutual encounter and upset that somebody just got mean? That's not what you call a rapist. You don't call your rapist mean. You call somebody that you had a contact with and they treated you the wrong way. Like, get the fuck out of my car. That might piss you off. That might get you upset. I guess he's being mean. So when you say get the fuck out of my car, does she get out and scream rape? You know, does she? No. I even asked her, remember, do you remember, were you making a scene? She goes, yeah, I screamed loud. You were able to make a scene, you were screaming things like, you pervert, you asshole. And she says, yes. So, once again, circumstantial evidence. One pointing toward innocence and one pointing toward guilt. Ladies and gentlemen, every single thing that she testified to, every single piece of circumstantial evidence to support her case points toward innocence. It points toward an encounter between her and the man that she was with, but not toward a rape. Because if she got ejected from the car, she'd be screaming and yelling down, following this car down the road, yelling, you know, police, 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 I've been hurt, I've been raped. But no, she's yelling, pervert, you asshole, you piece of shit. Those are the things she's yelling. And it's because he was mean and he kicked me out of the car. What did she do after this particular violent rape? You heard her, straight from the witness stand. I went about my day. Normal day. She told you that she walked around town, she talked to people, and this is the important part. She went down to the bus stop, the transit station, and the park. Right? The bus stop, transit station, and the park. Jane Doe 1 and Jane Doe 2 run in the same circles. You heard both of them say.
It's the evidence, facts not in evidence.
Argument.
Just a moment. Overruled. You can cover it in rebuttal. You can continue, Mr. Carlos.
You heard their testimony. You heard from Jane Doe 1 that she walks to the bus stop, to the transit station, to the park. You heard her say that, yeah, I know a lot of the people from the streets, either by name or just because I know them from being around there. Same thing with Jane Doe 2, who hangs out at the bus stop, transit station, and the park. So, she walks around in bloody pants for the rest of the day, apparently not traumatized and not really caring about her bloody pants, but just going about whatever day she had and not reporting anything to anybody, anywhere. You got a picture, you know, when I told you at the beginning here to have like a movie, you can picture her walking away, you know, after she gets kicked out of the car and she chases this vehicle, you know, toward the where the sushi restaurant is. She essentially had to walk through the entire parking lot. She had to walk. She told you she went back out to Santa Fe and then back down to the coast, which meant that she walked through this parking lot. Once again, some bombs. I don't know if you guys, I've never seen a bombs parking lot that isn't full. But this parking lot, tons of people. She took a left here, went by the banks, all the way to the street, walked all the way down to the coast, and then went about her day. Now, I agree with Mr. Owens that there really is no set profile for somebody, how they should react to rape or to being assaulted. But I don't think I'm being unreasonable by saying it's not this way. Clearly, the woman was not traumatized. Clearly, she was not raped. Everything about the encounter screams encounter and not rape. You know, and when you were listening to her testimony, you know I could see it in your eyes. I asked those questions from here, right next to the rail, to watch you all. And I watched you listen to the testimony. And there was some head shaking, there was some eye rolling, and that's well placed because that's exactly what was happening on the witness stand. She said some things on cross-examination also, which are troubling. One of the things she told us, I asked her, did you say that I put this man in a situation? Meaning that she put this man in a situation. And she says, yes, that's what I said. Now, is that something that a rape victim says? And she was essentially kidnapped and raped, but she's saying, I put him in a situation? She also told us, it's interesting, because I went through the trial testimony, and you can do this too. This is very interesting, that I asked her why would she get into the car if she's only hitchhiked 4 or 5 times in her life. Why would she get in the car? And you know what she said? She says, because he was a neighbor. Why would she say that? Even though we heard on direct that they were talking about him being from Oceanside, why would you say because he's a neighbor? And I followed up. And she said that maybe someone told her at a meeting, I don't know if you remember that, I said, well, like an NA meeting, AA meeting. She said around the neighborhood or at the park. Right? So what she let slip out, was that she knows who he is. She knew where the vehicle came from. She knew this expensive vehicle. She didn't have to know that he's a football player. They just have to know that he has money. They have to know that you know, this particular vehicle costs a lot of money, and people are talking about it. You know, the prosecutors say, hey, there's no evidence that they filed any lawsuits or anything like that. That's, you know, we all know what can happen. You get a conviction, anybody can go to the lawyer and get they can file a lawsuit. There's no evidence of here. They're saying they weren't asked whether that was the case. But they're certainly, this exchange here, when she told you that she didn't know who this person was, and all of a sudden said, well, he was a neighbor, that's why I got in, is very troubling. And it's there. It's in the testimony. Credibility is everything. And you have a woman who lied to you, who's clearly lied to you, and still wouldn't even admit that she lied about it. Your testimony is you never drank. She didn't say, I sometimes drink. She said, I never drank alcohol. Never drank alcohol. She swore to tell the truth, the whole truth, and nothing but the truth, and she did not do that in front of you. She follows up by saying, okay, not that I never drank alcohol, I was 30 years sober. Okay. Well, Jane Doe 1, what about these 6 arrests for being drunk in public? Well, I wasn't drunk. It was the cops. The cops harassed me. I drink a lot of cough syrup. I'm always sick. That's just a whole set of lies. Followed by, finally, when cross-examination finally beats her down to get to the truth, what did she say? And this is the truth. I didn't drink today. So she goes from this one here, from the witness stand in front of you, and went from never drank to I've been sober 30 years to I didn't drink today. You know, you can't put any faith in what she's telling you. There's nothing that corroborates her statement. There's nothing. Every single piece of circumstantial evidence supports this particular encounter that was mutual. And also, you can't accept anything that she tells you to support her statement because she lies when she wants to. She lied about menstruating. She lied about alcohol. Who knows what else? But she's willing to do it, and she did it. Not only willing to do it, but she did it. You know, the interesting thing, too, is she said that she never talked to anybody about this until she went to the police. Well, we know that most likely is a lie if we believe her daughter, Summer, who said that she told her she was attacked. But if you remember, Jane Doe 1 said she never told anybody. She went to the police. The last thing I wanted to say about her, you know, and this is just has to do with credibility and the reasonableness of her story. The question to her was, she was asked during her preliminary hearing examination, she says, we're getting this image, he's like buck naked, as in he has no clothes on, all the way down. You have clothes on, and you decide to jump over the fence. Do you remember that? Is that exactly what you did? Yes. So I can leave you with that image. If there's not a reasonable doubt, I don't know what is. A naked man, a naked perpetrator, a naked rapist on the other side of the fence that is this high at the very least. Okay? And you are 15, 20 feet from freedom. That is completely unbelievable. Don't tell me somebody's frozen in fear. Don't tell me everybody, you know, doesn't act the same way. Don't tell me that she's a deer in the headlights, because she's not. It just didn't happen. She engaged in the conduct. Summer Foster. Come on, seriously. Summer Foster. First of all, didn't know her mom was a victim. Even though her mom said that, hey, we believe her. Her mom told her I was assaulted. But let's take that for granted. She didn't even know her mom was involved in this case. And she's watching this thing on court TV with the cameras and everything. Watched her mom give the testimony that you all saw, so we all know what that means. She watched the commentary from attorneys who talked about how unreliable she was and how much damage she was doing. That's the most important thing. How much damage she was doing in the prosecution case, the first witness out. And what does she do? She calls the prosecutor. The prosecutors really jump all over this. They're saying, oh, great, this is going to help us. Did it really? You know? She came in here and said, oh, conveniently, I saw these pants and they had blood on them. Did we ever say that there wasn't any blood on any pants? I never attacked that. She conveniently said that her mom, this is important, her 55-year-old mom apparently can't use the computer and can't look up anything on SDTs and needs her help. That's completely unbelievable. Secondly, and more importantly, if you recall, she told you that her mom needed help in finding the sheriff's department, how to contact the sheriff's department. Do you recall that? Need help to get on the internet to find the sheriff so that she can make a report. And that is a lie. And do you know why? Question to Jane Doe 1. How was it you first contacted the sheriff's department? She said, I walked up there because I live right down the street. Did you ever call as you arrived? Call like what? Call before? No, I just walked up there because it's easier to do that. She lives right down the street. She lives walking distance from the sheriff. Summer Foster wants you to believe that she couldn't find the number or the contact information for the sheriff when they live right on the same street. So Summer Foster came in here to lie, and I can tell you what her motive is. That. She wanted $100,000. The one that's posted up there is $50,000. She posted this before she testified. She knew, and she's watching Court TV, that it's a national audience, that people might be glued to this particular case, that might feel sorry for her mom. So what does she want to do? I'll get $100,000 out of this thing. What's the motive on that? It's the oldest motive in the book. Pay me. You think $100,000, she'd get her mom therapy and relocation or whatever she wanted. At the end of the day, it's money. She knew full well that this was a national audience. It's not like any GoFundMe thing where you put it up there and hope people watch it. She would have a national audience. And what did she do after she testified? She went right outside and gave an interview to announce it. You are entitled to take that into account in determining the credibility of a witness. This witness is biased. She told you things that were just flat-out lies about her mom not being able to contact the sheriffs. She told you that her mom was like guarded, and she was very, very, she had long-standing problems, and that's the reason she can't communicate well. She had no problem communicating to you. She had no problem lying to you. She had no problem telling you a story. So don't buy that. You know, that's a daughter. She probably loves her mother, but she's trying to help her out. She's trying to come in and help the prosecution case out because she believes something happened. Her mom knows different because all of her conduct was different. So Jane Doe 2, I told you, is in the same area. She's down at the bus stop. She's down at the train station. She's at the transit center. What's important to understand here is this is another case where there's no independent evidence of any assault. It's a woman who points a finger. That's it. So realistically, she could have said this happened anywhere. She could have said they drove her under a bridge. He took me to Tijuana. He took me to Oceanside. There's no evidence of it. There's no evidence of a car driving down the road. There's no poll cameras of a vehicle being seen anywhere. There's nothing to support this particular assault occurred anywhere, except for Jane Doe 2. The SART exams, which she gave the next day, revealed absolutely nothing. Zero. Go back and listen to the testimony. The important thing to remember about SART exams is this, or any medical exam for that matter. The patient history is what more or less controls it. So I tell you this is what happened, and then they look for something which might support it. But this SART nurse told you, the same nurse, told you that these are findings. They're not conclusions. All they are her observations. Now, whether or not they support what the patient is saying, you know, it's up to interpretation of something else. She can't tell you what they mean. She can only tell you that they're there. she also can't tell you when they got there, how long they've been there, or what caused them. So what do we really have at the end of the day? We have redness on somebody that she's never examined before, redness in the vagina and redness in the anal cavity, and she's never seen this woman before. She told you that they can be the results. I actually used the words that she used. They could be from consensual, non-consensual sex, or non-sex related activities. Okay, so basically that's everything. Consensual, non-consensual, or non-sex related activities. I can't think of anything else. So she's telling you that these are things that I saw, I can't tell you what they mean. But, there are things that you can, right? She told you that the patient indicated that she had sex 3 days before, consensual sex. And these particular findings are certainly consistent with consensual sex. The findings that she did see, which are actually visible, are none. No scratches. Whoops. Sorry. Yeah, no scratches, bruising, no vaginal tearing, no anal tearing, or anything that could support a violent assault. Now, here's where you got to check in with a little common sense, all right? It's easy for an expert or anybody in the prosecution saying, oh, 50% of the time there's no injuries. What does that mean? Like 50% of the time people go to jail for the wrong reason? No. You need not check your common sense here, ladies and gentlemen. Just think about it. I want you to think about it. This is a former NFL tight end, right? With enormous hands. He's a big man. This is not, you know, a young, 150-pound man choking somebody, raping somebody. We know, at least from one witness, that he also has an incredibly large penis. We all laugh about that. But think about it, put that in context. The rape that this woman described, being thrown down in her seat, being vaginally penetrated, right? Held down, turned around, anally penetrated. She's not accepting these things. I mean, she's moving around. She has to like squirm and stuff. Then this 245-pound NFL receiver with large hands grabs her by the throat and chokes her. She can't breathe. She can't talk. It's pushing against her voice box. She says it changed her voice. You really, for 2 minutes, you heard the sergeant saying, 10 seconds puts you unconscious, 1 minute you can die. Think about it. Do you really, for a second, believe that there would be no marks? The first reaction, when the prosecutor was saying, what's your first reaction to in a choking situation? It's not what he said. Your first reaction is to grab the hands. Your first reaction is to dig your fingernails underneath those hands, to pull those hands off of your neck because you're dying, you can't breathe. The second reaction is to claw at the person who is strangling you. But nothing. There's nothing here. Zero. It's unsupported. All of her version of the assault is unsupported. The route of travel is unsupported. The previous relationship is completely unsupported by any facts or evidence. Think about it. This is a homeless woman who told you she has to get food off the street. She has food in a food bank or in a garbage can. She has no money. But Kevin offers her money and she says she never took it. She says she only rode with him one time before. One time. Right? You remember that. She rode with him the first time and then the night of the assault. That's what she told you from the witness stand. But Christina Garvey told you that Jane Doe 2 had indicated that they'd had coffee 6 times prior to her being taken advantage of. 6 times. That requires her getting into the vehicle and going somewhere for coffee, if what they're having is coffee. On the date that she got arrested, on the date that the assault, remember, She ran to this vehicle. She was happy to see the vehicle. You know, she rushed over there. She saw Kevin there in his vehicle. She said, "How you doing?" She went back to get her bag, right? And then she went back and got into the vehicle. She was so rushed that she left her phone with her friend. Clearly has been in the vehicle with him in the past. And she even told you from the witness stand that she told her friend that she was leaving to go for coffee with Kevin. And she told you that was my suggestion. Not Kevin's suggestion, that was my suggestion to go for coffee. You know, if Mr. Winslow was this like crazy rapist, he had 6 other opportunities to rape this individual. If he is this groomer of victims, he had plenty of time to do this. What was it about this night that he couldn't control himself? What was it about this particular night that he said, "You know what, I'm tired of all this coffee drinking, I'm gonna rape you"? What evidence do they have of that? They have nothing. They have just as much as Jane Doe 2 has about what happened. Most importantly, she never told the police about the discussion of sex for money in the past. That's important. And the reason it's important is because they asked her, why would he want even sex from you? I don't know. I have no idea. We never talked about it before. But it wasn't until the day before the prelim when she knew that she was going to testify under oath. She knew that she would have to, raise her hand and she might get cross-examined by somebody. That's when she said, "Oh, by the way, I forgot to tell you. Yeah, he did ask for sex for money before. $40 or $50. There was some talk." So you got to wonder how much more there was. You got to wonder why she withheld that information. She also told Officer Moses the day after the event that the choking that she witnessed was not related to the sex rather than the event. So that's important also because she's looking at it in a different perspective, not as in a violent rape as much as just the same thing that she said about the accidental anal penetration. I mean, why would you say it was accidental if you're being raped? I mean, how does that pop into your mind that it's accidental that you have been anally penetrated? Same thing as the choking not being related to the sex, not the screaming. I mean, all of that is something that you need to consider. Likewise, the ride down Manchester and then the abrupt U-turn that she took. All right, let's get this out of the way. We all live here, right? This is not some foreign country. This is San Diego, California. It's not the country. This is not a deserted road. Manchester is a major road that goes to the Interstate 5. And it's not like it's 5 miles from the 5. It's within a half a mile of the 5. So it's not like this is some country road. We played this. Take a look at the road. Imagine, even at night, where's he going to park? He's going to flip a U-turn. We're going toward the freeway right now. Where's he going to park? Do you really think that there's no cars traveling on this road at any time? I mean, do you really believe that this is a deserted road? Absolutely not. He would have, according to Jane Doe 2, would have had to flip this U-turn and then rape her, get out of his car, go to the passenger side, open the door to the Hummer, and you know what happens when you open a door to any new car? The dome light goes on. So the interior of the vehicle would have been lit up. It's this huge Hummer, and he's raping her on the side of the road where it would stand out like a sore thumb. Is that very realistic? No, it's not very realistic because it didn't happen. There's no evidence of it. There's nothing. There are no witnesses to it. This is all her version of events, which is unsupported by any type of evidence, just like that's what I'm saying. You can support, and there's no evidence. Just like the neck. That's the kill. The most important part of Jane Doe is the neck, and the reason is her description of the choking ramps up the violence of the case, ramps up the violence of the attack, and we know that isn't the case because there are no marks. She claimed that she was choked for 2 minutes. You heard it from I said it before. There's no marks on here. Look at the pictures, right? Nothing. Zero. Nothing. This is the day after, not a week after. This is the day after. Are you telling me that a 240-pound football player with large hands, who has your hands around somebody's neck, who is choking you for 2 minutes and choking the life out of you to the point where you can't breathe and you can't speak, and there's not even one tiny little bruise? Zero. You have these pictures. You heard about the petechiae, which is an indicator of somebody being choked. Nothing. Zero. Don't tell me that 50% of people don't have any marks. Don't tell me that that's what you're going to hang your hat on, because this would leave marks. This particular event, holding somebody down, a larger, stronger man would have left something, and there is nothing here. And why is it important? Because of this. I asked her, did he put 2 hands on your throat? Her answer was it was 2 hands. And he knew he's smart because he did it in a way that he can't leave any marks. He did it in a way he can't leave any marks. I'll tell you why that's important. It's important because she looked at the photos. She saw the photos.
Objection, facts not in evidence, and this needs to be evidence.
Sustained.
She
I'm
knew.
going to ask for an admonishment to disregard the last comment.
All right, the jury will disregard the last comment, although, as I've told you before, what the attorneys say is not evidence. If anything they say contradicts what you find from the evidence, you go with what you find from the evidence as well. All right? Go ahead, Mr. Carlos.
How's this? She looked in a mirror, saw there were no marks. Okay? Sometime after she reported this thing, after she reported this strangulation, this choking by this man, she looked in the mirror and saw that she had no marks. Nothing. Zero. You didn't hear anything from any evidence tech about DNA found in her fingernails, from the scratching she did of this individual, about any bruising that was on her hands. Remember she said that this guy grabbed her by the hands and pushed her down? No bruising on the hands, no bruising on the fingers, no bruising on the legs, no bruising on the back, no bruising on any single part of her body. Nothing. Zero. No evidence whatsoever. So, ladies and gentlemen, let's be clear about this. The only evidence of any assault comes from her, and that's it. Don't be fooled to say there's some type of circumstantial evidence that they presented which is credible, because there's nothing. In fact, everything points the opposite way. She's being less than honest with you about the choking, clearly, to make it sound worse. We know that she's talked to people, that she talked to her friends, and her friends know that this person drives this car. It doesn't take a rocket scientist to see where this is headed. You don't check your common sense at the door. You get to use it if you apply the law the right way. Jane Doe 3. At the beginning of the case, Mr. Watkins got up and told you about this particular case. And we said that we were going to show whether that at least Jane Doe 1 and Jane Doe 2 were related to a bias or a motive. And I think we've established that. Jane Doe 3, right, is something that essentially law enforcement put together. Because what we know is Jane Doe 3 didn't identify anybody. So the police showed her the picture. The police brought her in. The police are the ones, the prosecution are the ones who are putting her up there. And I'll go to Jane Doe 4, obviously had a reason to, she doesn't like Mr. Winslow at all. So she has a motive. And Jane Doe 5 is another created by the media because Mr. Winslow was all over the TV. I'm going to stay with Jane Doe 3 for right now. I want you to think about what Jane Doe 3 said. This is a woman who has seen this guy David and spoke to him on a previous occasion. See him, talk to him, look at him. That's what she saw. The second occasion, he spoke before he exposed himself. So once again, she got to see him. Police showed her a photo lineup. And she said none of the photos were the suspect. Right? Mr. Winslow was in that photo lineup. She came to a preliminary hearing and testified in court with Mr. Winslow sitting at a table. She couldn't identify him. She came to trial, right? Sat here, Mr. Winslow's right in front of her. She couldn't identify him. And you know what's really important about that? They didn't ask him to. Mr. Owens Could have said, hey, is that the guy over there? Because he knew what the answer would be. She'd say no. It's what she told everybody else. Why wouldn't he ask that? She identified the tattoos, blue, like the flag, right? Similar to the police officer in the body cam. He had some blue tattoo. She pointed, and I don't need a picture for this, but she pointed to that flag up there. So we all see what color blue she's talking about. You can look at Mr. Winslow's tattoos, and you can see there is not one piece of blue on there. There's a green, and there's an orange, and the rest are, like Mr. Watkins talked about, tattoo green, dark color, not blue. Can't even be confused with blue. The picture that is shown to you right there, the bottom part, is from the body cam of the officer when she was talking to Jane Doe 3 and talking about the color of her tattoos. He rolled his sleeve down. You have access to the video, you can watch it. But he showed this blue to her, and she said, something like that. So we have the blue, the color of the flag, but clearly the blue, and not dark tattoo green. She also said that she described him as 5'8" to 5'9". Remember, she's seen this guy 2 times. And she used an officer as a guide to say how tall he was. And said the build of a cyclist, not a bodybuilder. It's a big difference between somebody who's a cyclist and somebody who's a bodybuilder. And so clearly, this individual is not the same person, but at least the individual who exposed himself is not Mr. Winslow. So they presented you with some Strava information, right? Shows the routes that Mr. Winslow may have taken, or at least his application took from a bike. And what it did is it put him in the vicinity the day before, the vicinity of the victim, Jane Doe 3. But there's no credible evidence that the route went into her driveway. They're saying, yeah, it's close to it. No one really says that this is where it went to. But it's important, though, on the day of the actual exposure, Mr. Winslow, if he was on his bike, and that is his Strava route, was going the opposite direction and didn't go in there. Clearly, he wasn't even there, by their own evidence. So Jane Doe 3 didn't see anything, didn't identify Mr. Winslow. There's no evidence that puts him there. There's no evidence that, other than the prosecution is saying that it's him. She clearly can't say that it's him. Jane Doe 4. Now, Jane Doe 4 is, I don't even know how to start with Jane Doe 4. Jane Doe 4, something happened to her in high school. Clearly, she's upset with Mr. Winslow and has harbored a long-term resentment for Mr. Winslow. Because we know that she had, at least by her testimony, had consensual sex with him. And then Matt came in. She didn't like what happened. She had a bad experience with him. Regardless of what experience she had, she waited 15 years to disclose this to the authorities. 15 years. And in between that time, just told, well, we'll get to Nikki, but her boyfriend Guillermo and then her husband later about an alleged assault. But what really tripped things up was she saw a Sports Illustrated article about this man, Mr. Winslow. And Mr. Winslow, who had everything. I'll be honest with you too. You heard it from the prosecutor too. He was a star. He was all pro. He was a professional football player. He had everything. And Jane Doe 4 knew that. But now he's being accused of rape. And she reads from Sports Illustrated that they may use CTE as a defense. That the defense may say it had something to do with his trauma to his brain as a result of playing football. But so Jane Doe 4 would have none of that. None of that. He's not getting away with this thing. There's no way he is. So she contacts her friend Nikki. Nikki, you remember? Do you remember? And then she didn't remember at first. You can read through these things. Didn't remember at first, but then, oh yeah. Prodding. So Jane Doe 4 says to herself, and she said it on the witness stand too, that she wanted to support the victims, right? Whether what they're saying is true or not, she didn't care. She wants to support the victims. So Jane Doe 4 inserts herself into the case. She decides she's going to call the police. I'm going to call them, I'm gonna call law enforcement and I am going to relate what happened to me. Right? Now this is really, really, really important because the prosecution doesn't even want to address it. They didn't do it in their direct, and I challenge them to say something on their rebuttal about this because they know what it means. Because Jane Doe 4 had the opportunity to think about what she was going to say. She had 15 years to think about what she was going to say, and she picks up the phone and she calls the hotline from the article she was reading. A hotline that goes directly to the investigation of Kellen Winslow. Call goes in to the sheriff. It gets directed to Sergeant Emig. And Sergeant Emig is not just some guy sitting at a desk. He's not some guy like in a TV program that you see you saying, yeah, whatever. He is the supervisor of sex crimes. Supervisor of sex crimes. His job? To basically make sure the investigation of sex crimes is done correctly by his officers, to manage them. He has experience, he has training, he's written hundreds of reports, if not thousands in these years. So believe you me, when the call comes in, he's taking note of what they're saying. He's not just saying, oh, this is just some nutcase. So he's taking note of what this person is saying.
All right, Mr. Carlos, let me interrupt right now. I received a note that we need to take a courtesy break at this point. I hate to interrupt you at this point, but we do need to take a break. So we'll take a 15-minute break. We will see you back here in 15 minutes. Please remember the admonition. Don't discuss the case with anybody. We'll see you back here in 15 minutes.